Hello, I'm David Roger, General Counsel for Las Vegas Police Protective Association. In this case, I want to talk to you about a recent Ninth Circuit Court of Appeals case which refused to give an officer qualified immunity when the officer failed to call for medical assistance for a person who had been involved in a crash. And so the case that came down March 12, 2025 is DeBronstein versus California Highway Patrol. In that case, DeBronstein was involved in a single car accident. The highway patrol trooper pulled up, saw that there was substantial damage to the vehicle. The airbags had been deployed, and from there the trooper contacted DeBronstein. It says that the officer started conducting a DUI type of investigation. In speaking with Dabrowski, the decision says that DeBronstein said that he had been driving the car at about 20 miles an hour and that he didn't know what happened. The car did something. The trooper observed that DeBronstein exhibited a dry mouth, slurred speech, profuse sweating, confusion, poor balance, slow reaction time, and constricted pupils. In speaking with DeBronstein, he made multiple spontaneous and incoherent statements. DeBronstein had difficulty answering basic questions, including where he was going and what had caused the collision. And from there, the DUI van showed up. DeBronstein blew a 0.00, no alcohol in his system, but the trooper concluded that he must have been under the influence of a controlled substance and placed him under arrest. The trooper then took DeBronstein to the jail. The medical nurse found that DeBronstein had elevated blood pressure and refused to admit the individual. Thereafter, the trooper took DeBronstein to the hospital, and it turns out that DeBronstein had suffered a stroke prior to the accident, and DeBronstein later sued the trooper, saying that had he received medical care in a timely fashion, his stroke could have been mitigated by medical treatment. And so in discussing the case, the Ninth Circuit talked about an officer's duty to obtain medical attention for an individual who has been arrested. And the court explained that objectively reasonable post-arrest care, which means that police officers must seek the necessary medical attention for a detainee when he or she has been injured while being apprehended, by either promptly summoning the necessary medical help or by taking the injured detainee to a hospital. And here is kind of an interesting case. It also says that this does not require an officer to provide what hindsight reveals to be the most effective medical care for an arrested suspect. Thus, in Tatum, we held that officers who promptly requested an ambulance for an arrestee but did not perform CPR on him acted in an objectively reasonable manner. And so there are some officers who believe that they have to perform CPR and all these other medical treatments, and at least the Ninth Circuit has said that you don't have to go to that extent. As long as you call for medical, then you have met the objectively reasonable standard. And so the court concluded in this case, Durazo encountered DeBronstein soon after he was involved in a major collision that destroyed his car and caused the airbag to deploy. Bronstein was disoriented, sweating profusely, had poor balance, his pupils were constricted, and his speech was slurred and extremely slow. He had difficulty answering standard questions and could not perform the field sobriety test as directed. The trooper told Bronstein at the scene that he had a serious condition, and yet for reasons that are difficult to understand, the Rosso did not call medical personnel to the site of the crash. She instead took Bronstein to jail, and she did not bring Bronstein to the hospital until hours later, and even then, not until a nurse at the jail refused to admit Bronstein due to his medical condition. And so the court concluded that a reasonable jury could determine that the trooper's failure to call medical at the scene was not reasonable, and that it contributed to his stroke and his subsequent condition. So this does not mean that anytime you do a DUI and the person isn't able to answer questions and you have no reason to believe that the person could have been injured, that you have to stop field sobriety test or call medical immediately. In my opinion, this case deals with an accident where an officer should know that the person may have been injured in the accident, and regardless of whether the individual asks for medical, officers should call for medical so that the person can be evaluated at the scene. This is an important case, and as a side note, as we discussed a minute earlier, you are not required, at least according to the Ninth Circuit Court of Appeals, to provide medical care yourself. It is sufficient if you call for medical. I know that in this day and age and with policy, officers believe that they have to provide medical attention by doing CPR or otherwise. But understand that at least from the Ninth Circuit's position, as long as you call for medical at the scene, you will be given qualified immunity. As always, thank you for listening. If you have any questions, please contact me at droger@lvppa.com. I will also attach a copy of this decision to the email that we send out.
111, 110.